Hi, my name is Malia. My presentation is on environmental human rights, where they stand and how they're helping the youth of today. The impact of global warming on the youth of today is confrontingly clear. Young people in vulnerable communities are already facing significant repercussions due to climate change, and the future is not looking bright. Currently, between 3.3 to 3.6 billion people are estimated to be living in highly vulnerable conditions due to climate change. Studies have shown that on our current trajectory, an estimated 48,000 children under 15 will be killed by 2030. Vector-borne diseases due to heat waves causing severe illness in our youth during their most vulnerable years of development, and this problem is only growing in scale. This is not only an issue for today's youth, future generations are set to start on the back foot. It has been assessed by experts that there will be significant impacts on maternal health due to the global rise in temperature. Heat waves in particular are likely to increase rates of preterm birth, stillbirths, and neonatal stress. These will impact child health long term and prevent many children exposed to these conditions from thriving throughout their childhood and adult lives to follow. Environmental human rights provide a legal avenue for youth to advocate for their future. In this presentation, I will discuss how youth are currently using the legal concept of a right to a healthy environment to advocate for their future on this planet, and how this could support the fight against climate change. Preventing the harm caused by climate change is a duty we not only owe to ourselves and those younger than us, but those yet to be born who will inherit the earth and the state we leave it in. There's been much tension between environmental protection and human rights, and it isn't too hard to fathom why. Many theorists are of the opinion that the fundamentals of human rights and environmental protection clash. Environmental protection is obviously based in the intrinsic value the environment holds, and framing this in a way that prioritizes those who reside in it, humans, essentially disregards the entire purpose of environmentalism. Some environmentalists see this utilitarian way of approaching environmental rights as disrespectful to the planet, and see environmental protection and human rights as irreconcilable concepts. This can be seen from a different perspective if we look at environmental human rights through a wider lens. Some present a counter-argument that considers the benefits that merging the concepts may have. Adding a human rights approach to environmental protection, regardless of the motive behind it, may give an edge that is desperately needed to impose meaningful change. As Professor of Law Rebecca Bratsby argues, a new level of urgency may be injected into the process by emphasizing a clear link between the fundamental human right to life and a healthy environment. Without a stable, clean environment, we as a species cannot properly function. One further challenge that faced when attempting to establish a human right to a healthy environment is the viewpoint that this right is of a lower class to more easily enforced negative rights, such as the right to be free from torture. While admittedly it is easier to refrain from teeth pulling than to enact initiatives that reduce global carbon emissions, this does not make this right of a lesser importance, and it could be said that the only difference in suffering caused by the breach of either right is the immediacy of human pain. Anton counters this argument far more eloquently in recognizing that as light is shed on the fundamental nature of environmental preservation, society will move to accept its place amongst other core rights. Initial legal recognition of a right to a healthy environment can be credited to the 1972 Stockholm Conference on the Human Environment. Principle 1 states that man has a fundamental right to freedom, equality, and adequate conditions of life, an environment of equality that permits a life of dignity and well-being. This explicit mention was a catalyst in the inclusion of environmental human rights in further international documents. The Rio Convention followed in the footsteps of the Stockholm Conference, strengthening its provisions and mentioning the environmental needs of present and future generations. International rights instruments, such as the International Covenant on Economic, Social, and Cultural Rights, and the United Nations Convention on the Rights of the Child, followed suit, with nods to environmental human rights. And crucially, many have interpreted the Universal Declaration of Human Rights to include environmental rights. Many of its provisions cannot be upheld without the existence of a healthy and clean environment, the most obvious example being Article 2, the right to life. Without a clean and stable planet, those exposed to the harshest conditions caused by climate change are deprived of this fundamental right, as is being seen globally through the rise in natural disasters. The 2015 Paris Agreement also plays a key role, as states agreeing to hold the rise in global average temperatures below 2 degrees stands in support of a human right to the environment. In terms of recent case law, Duarte was the first climate case to cross the European Court of Human Rights. 6 Portuguese children brought forth a claim that the Portugal government and others in Europe had failed to meet their obligations under the Paris Agreement to reduce greenhouse gas emissions. They argued this violated their right to life under Article 2 of the European Convention of Human Rights, as it contributed to the acceleration of the climate crisis. This case may have been unsuccessful due to a failure to exhaust domestic remedies, but the avenues it opened for future youth climate litigation cannot be overlooked. In Held v. State of Montana, we saw the first successful climate case relating to environmental rights in the US. 16 youth plaintiffs challenged the Montana government in their support of fossil fuel development, claiming this failed to uphold their constitutional duty to maintain and improve a clean and healthful environment for future and present generations. This constitutional provision was notably rather explicit, but the court's ruling in favour of the plaintiffs was a landmark victory and one of the first instances where a court recognised the connection between government action, climate change, and the constitutional rights of citizens. Furthermore, in Future Generations v. Ministry of the Environment, we saw the enforcement of actual action against the Colombian government for their failure to protect the Amazon rainforest. Not only did the court rule this to be a breach of the plaintiffs' rights, but they also ordered the government to work with local communities in establishing a plan to protect the rainforest in the future. The court's retention of jurisdiction over this case until the government's obligations have been fulfilled means this can't be another case where the state's obligations are swept under the rug once enough time has passed. A step in the right direction compared to the empty promises states have made in the past. What does this all mean for the future? Recent climate litigation demonstrates that domestic legal action can create real change in governmental climate policy. Countless cases are beginning to demonstrate that the right to a healthy environment has been taken seriously on a global scale through the actions of youth groups advocating for their rights. These cases are taking youth advocacy to the next level. We are seeing courts imposing actual obligations upon governments as a result, unlike past efforts of youth that have focused on increasing awareness. It also demonstrates that international battles are not necessarily needed to achieve significant positive action. Although creating international obligations surrounding environmental human rights presents as the most substantial way to enforce meaningful change, climate litigation demonstrates that this is not needed to make an impact. International agreements are notoriously difficult to achieve, and it is likely that resources are better spent fighting for this right on a national level. With that said, Duarte proves that this is still a viable option. If state action fails, there is now a possibility for ground to be made in international courts, if approached in the right way. I would like to conclude with some comments on the way forward in climate activism. From my point of view, it is evident that older generations, although their efforts are not entirely absent, are not and will not do enough to prevent the deterioration of our environment and the environment we will pass on to our children. From my perspective, the only way forward in the fight for the healthy environment is for young people to fight these battles themselves. As demonstrated by the climate litigation discussed, these cases are making a genuine impact in state policies and are causing real change in government action. Advocacy may contribute to the fight, but it will not be enough. This is not to say that advocacy efforts are in vain. Increasing awareness is a crucial part of the battle, but the ground that can be made in utilising the human right to a healthy environment is far more substantial and will take us further than protests ever could if utilised to the fullest. Thank you.